The topic is the patient's rights, ethical, legal and ethical perspectives. So many things may not be new for you, but I can guarantee there is at least one item which must be new for many of you. So hold on to this presentation and let's go on it. So the scheme of presentation, we will cover the ethics and laws. Even though this is not a session on ethics and the law and how to contrast and compare them, but it's important to understand the fundamental differences between the two and to know how we address them. When we look at the fundamental principles of ethics as it applies to the healthcare system, we look at human rights and patient rights. Patient rights, as we are supposed to know, and two more topics after that. How to monitor the implementation of the patient rights in your hospital, rather the requirement of monitoring, and the violations that sometimes happen, and then what are we supposed to do about it. So ethics are the principles that guide a person or a society created to decide what is right or wrong. So if you recall if you have attended sessions on ethics and morals and ethics, morals and laws, you can recall that the ethics is something that applies at the level of society. So what society as an entity thinks right or wrong is something what is called the ethical principles. And the same thing if it happens at a personal level. So at an individual level, I think what is right or what is wrong. But if it is not in line with what the society thinks, then my moral perception may not be in line with the ethical requirements of the society in which I live in. So therefore, the ethical principles of conduct of professional groups, for example, the doctors or the lawyers or similar professionals, the chartered accountants and the engineers, are decided by the respective professional communities or the respective professional societies. And they are also coded in terms of the rules for professional conduct. So this is what the ethics are. They are the principles that guide a person's actions or the conduct in respect to a society and to decide whether these conducts are right or wrong. It regulates a person's behavior or a conduct and helps an individual in living a good life by applying moral rules and guidelines. Please remember that the difference is that the moral rules and guidelines when applied in the context of a society. So the ethical principles guide people about the basic human conduct in a society. And these are a set of rules. I'm sure all of us are aware about the ethical rules or ethical conduct which are given by the Medical Council. And likewise, there are rules, ethical rules or ethical principles of conduct by almost all professional societies. So these are meant to help people to decide what is wrong and how to act. And then the violation of ethical conduct, something what is called unethical conduct, may lead to or may not lead to punishment. So this is gray, this is fluid, this is gray. That every violation of ethical conduct or every unethical conduct may not necessarily lead to a punishment. And this is in contrast to the law, where the laws are the set of rules and regulations created by an authority. Now, this authority can be, in most instances, this is the government. It can be a regional, local, or international law, depending on who has created it and on whom it applies. And the law, unlike a guideline, like ethics, they are ethical guidelines. So unlike the guideline, a law demands compliance and it can enforce certain way of conduct. So whenever we talk of law, then there is an possibility of an enforcement and the violation will invariably invite punishment. So when there is a law, then law means that it has to be followed, period. There is no debate on that. Whereas on unethical conducts may or may not invite punishment depending on the context and whether it gets reported and whatever else. So Here the intent of the law is to provide protection to all the citizens. So please remember, the ethics and the laws will exist together at the same time. The law come into action when the ethics-based regulations fail. I will come to this statement again a little later in the presentation. So whenever the ethical conduct is found wanting, then one can always be assured that the law will take the place, or the law will come into the picture and will demand compliance with a certain way of conduct. So, for example, I mean, there are examples which will come up later in the presentation, but let me state one here. For example, we have known about the unethical conduct by the professionals in the hospitals, and many times these unethical conducts get challenged, and then the courts of law will give a ruling, and they will get to decide whether a particular conduct was ethical or unethical, and that of course will, if it is by a Supreme Court, then it will become a case law, and in that case it becomes binding to everyone else. And in many instances, for example, Consumer Protection Act covers many aspects of ethical conduct by a professional, and then the law has come into place because the ethical conduct was found wanting. So this is something that will happen if the ethics-based regulations fail, then the law comes into the picture. So what are the fundamental principles of ethics as it applies to the healthcare? So we talk about 4 principles. One is the beneficence, non-maleficence, autonomy, and justice. So these are the 4 principles based on which we will see and we will look at the patient's rights. So the first 2 principles of ethics, that is the beneficence and non-maleficence, is something that has existed from the very beginning of the modern medicine, and it exists in almost every profession. And the fundamental, the simpler way to put it is to help and not to do harm. I think first do no harm is a principle based on which the entire modern medicine exists or is need to exist. Then autonomy and justice are the 2 principles of ethics which got added later as the societies evolved, and then they gained acceptance as the principles of ethics. So let us look at each one one by one. So beneficence means an obligation to act for the benefit of the patient. So our discussion today will be in the context of the healthcare system. And whenever we say beneficence as a principle of ethics, all physicians, all healthcare providers are required to act for the benefit of the patient. What does it mean? It calls for not only avoiding harm, but also to benefit patients and to promote their welfare. So the patient's welfare and patient's well-being and patient's benefit has to be the primary principle based on which the healthcare has to be, the care has to be delivered. The next one is the non-maleficence, and this is from a principle called primum non nocere, which means first do no harm. So physicians are required to weigh the benefits against the burdens of all interventions and treatments, and to eschew those that are inappropriately burdensome, and to choose the best course of action for the patient. So first one is, you can say, has a positive connotation, where beneficence means that you always look for what is beneficial to the patient and what is going to be for the good of the patient. And the non-maleficence is that you avoid harm by all means. This is particularly important and pertinent in difficult end-of-life care decisions. In fact, many medical decisions will need consideration of this principle when we take care-related or care delivery-related decisions in our day-to-day practice. So the next one is the autonomy, and this simple principle of ethics relies on the fact that all persons have intrinsic and unconditional worth, and therefore should have the power to make rational decisions and be allowed to exercise capacity for self-determination. That means only I can decide about myself, about me. So this is the principle which basically means that whenever there is an intervention that needs to be done on my person, then I will take a call. And this needs to be weighed against the competing principles. Now, sometimes there may be competing principles where this kind of an autonomy is restricted. For example, whenever an autonomous action can cause harm to another person, then obviously a person cannot act in a manner and say that, okay, I am acting autonomously and this would result in harm to someone else. So something like the freedom of movement is there, but in the name of that freedom, you can't possibly kill somebody using your vehicle. So this is also restricted in certain instances. But as far as a person is concerned, for the purpose of receiving healthcare, a person in the having the ability or the competence to make a rational decision is to be allowed to exercise capacity for self-determination. And this understanding comes very handy when we talk about informed consent. And I'm sure you also would have faced, and I've also heard a number of times, where the common understanding or the common refrain is that the patients don't understand, and therefore it is so difficult to explain to them the pros and cons for a particular surgical procedure. But then please remember that the principle of autonomy works, and therefore once it is applied and the patient is in his having the capacity to understand, then he will take a final decision, and that is where the informed consent becomes very, very important. So this, since this discussion is on the patient rights and is not on the ethical principles as such, so what we are saying is in a very, very abridged version, and to ease our understanding about the basis from where the patient's right come about. So whenever we talk about autonomy, then we need to weigh this against the competing principles, and my autonomy obviously cannot come in the way of somebody else's life and liberty. So therefore, there will be some restrictions as well. Now, those who lack and of course, this autonomy principle does not apply to those who lack the competence to act autonomously. And therefore, whenever you take the consent from with respect to a child, when you take a consent with respect to a person who is mentally challenged or physically challenged because of effects of medications or whatever else can be the reason, then that person or that patient is supposed to be incapacitated in terms of ability to take the autonomous decision, and therefore the consent is then obtained from another person. For children, it may be one of the parent, and for mental and physical incapacity, there can be a guardian. So therefore, the principle of autonomy works like this. The applications of this are when we take consent, when we talk about transparency in our dealing with the patients, and when we talk about confidentiality. The next one is the principle of justice. So this relies on the fact that people receive that which they deserve. Now, how do we decide who deserves what? So physicians must accept the requirement of fairness contained in this principle, and there is something what is known as equitable distribution, or something. For example, we talk about triage in terms of our healthcare practice. And when we say triage, essentially what we are trying to do is we are trying to identify patients who require urgent care or who can benefit most from the care, and therefore we provide care to those. So essentially here what it means is that we identify those who can be benefited the most, and then we provide them that care. For example, a violation of principle of justice would be when a particular option of treatment is chosen over an equally effective but less expensive one because it benefits the physician financially or otherwise. So this is an example which is given in one of the texts that I referred to. Essentially means that you need to be fair in your dealing with the patients, and this principle of fairness comes into play when we look at the patient rights. Triage, as I have said, is an example of what we do in our healthcare settings, and this involves principle of justice. Next, we need to look at the human rights, and there is a Universal Declaration of Human Rights of 1948, It emphasizes the fundamental dignity and equality of all human beings. So based on this, the notion of patient rights have developed. The National Human Rights Commission in India in 2019 adopted a Charter of Patient Rights, and I am not sure how many of you are aware that there is NHRC Charter of Patient Rights. This I'm providing it as a download, and you can log into through your account and download this for your use. This is something which is also available on the NHRC website, but you don't have to really go there and get it. But I'm giving it here. So this is patient is entitled to certain amount of protection to be ensured by physicians, healthcare providers, and the state. So the Charter of Patient Rights, whatever patients' rights have been bestowed upon the patients, are conferred or they are available to the patients. These are to be ensured, and they obviously the rights give certain kind of protection, and this protection is to be ensured by physicians, that is the care providers, the organizations that provide care, that means the hospitals, as well as by the state. So let us look at how these three entities provide it. So the protection by the physician is provided, and this is usually encoded by the rules of professional conduct. You have ethics guidelines and ethics rules for doctors and other professionals. The protection by the healthcare providers, that the hospitals and the organizations, these are usually the mandates assigned by the administrative rules and laws. So one example which immediately comes to my mind is when the state governments mandate that 25% of the beds will be reserved for the economically weaker section, or there will be certain percentage of free OPD available in the hospitals. So these are the kind of administrative rules that are brought in by the governments to provide protection to the population and people. And lastly, the protection by the state. The state usually provides protection by enacting laws, and we are aware of a large number of laws which are applicable for the benefit of the patients and their protection. So any right which is applicable to a citizen is equally applicable to a patient. So please remember that. So if the right to information is conferred by the Right to Information Act, then this right is applicable to every citizen. Now, and this RTI is a right to information is applicable to every citizen, and similarly it is also applicable to every patient. Now, why I have brought in the example of RTI is for a reason. Now, if you read the law as such, the RTI Act itself, it is applicable only to the governments or the government organizations funded by the government, whether funded partially or fully, that doesn't matter. So long they are supported or funded by the government, this particular act is applicable. Now, how does it apply to the private hospitals which are not funded or not supported by the government? Now, please remember that the Code of Medical Ethics, which is by the Medical Council of India, mandates that this information will be disclosed. So this was already applicable much before the RTI came into being. And then we also have case laws. Of course, Dr. Ashish is aware, but case laws are the judgments by the Supreme Court and by the various courts that have the writ of mandamus, namely the High Courts and the Supreme Courts. So the judgments become the case laws. That means if a judgment is given by a Supreme Court in a certain manner, then it becomes applicable as the case laws. Now, some of the examples, one more aspect is that sometimes the rights that are applicable through ethical requirements or administrative rules can also get re-emphasized by case laws. For example, you have the right to emergency treatment. That this is a right that always existed, but of course, some hospitals at some point in time declined treatment. That prompted one Pandit Paramanand Katara to file a public interest litigation in the Supreme Court, and this was a famous case. You can download it from the internet, freely available judgment from the Supreme Court, and this is a judgment which has entitled or which has mandated that every medical establishment will provide emergency treatment to the patients who come to them for emergency requirements. So this is something this existed even before this judgment, but here case law came into the picture, and therefore it gets mandated as a law as well. The second example is this case, which was again a judgment by the Supreme Court called Samira Kohli versus Dr. Prabha Manchanda, and this talks about the consent. So we talked about the autonomy, and if you read this judgment is one where they have emphasized and clarified the concept of autonomy as it is applicable to a patient. So we need to understand that the ethics-based regulations can sometimes get converted into case laws, and then they become binding, and the violation can invite punishments. So let us now look at the patient's rights. I'm sure many of you have seen the patient's rights that are listed in the NABH Standards 5th edition. Why I have chosen to list the rights as per the NHRC Charter is because this is the guideline by a national National Human Rights Commission, and this is it's a statutory body, and therefore the guidelines or the guidelines adopted by them hold a higher value than the NABH standards per se. So therefore I have listed them, and I will just go to all the 17 patient rights that are listed in this NHRC Charter. The first one is the right to information, right to records and reports, right to emergency medical care, right to informed consent, right to confidentiality, human dignity and privacy, right to second opinion, right to transparency in rates, that is the charges, and the care according to the prescribed rate wherever these are relevant, right to non-discrimination, right to safety and quality of care according to standards. Please remember that this is a right conferred listed in the NHRC Charter, and therefore compliance to evidence-based treatment becomes important. Right to choose alternative treatment options if available. So the patients can choose treatment options which are alternatives. Right to choose the source of medicines and tests. So you can't tell the patients to buy a medicine from a particular shop or get the test from a particular hospital or a particular testing lab. Right to proper referral and transfer free from perverse commercial influences. Right to protection of patients involved in clinical trials. Right to protection of participants in biomedical and health research. Right to take discharge of patients or receive the body of a deceased from the hospital. So you can't hold a patient or hold a body for want of non-clearance of your bills. Right to patient education, and right to be heard and seek redressal. So these are 17 rights. The NABH standards do not list many of these. But then these, if you really look at the entire standard of NABH, these are included in multiple places. Now, if you read this document, which we are providing as a download, and which is the NHRC Charter, for each of these 17 rights, they have given a beautiful description and also the basis based on which this is included in the NHRC Charter. So many times you would see that the basis is the Supreme Court judgment or a particular ethical principle. So this document, that is why, becomes an important and a good document to refer to. So next we look at how to monitor the implementation in the hospitals. So the patient's rights have to be bestowed upon the patients, and the patients may need to be educated about these rights. So just like the Election Commission of India keeps educating us about our right to vote and to vote based on the informed judgment, similarly the hospitals are required to train, to educate the patients about the rights that are applicable to them, as also how to report the violations of those rights. So the NABH standards require that the patient education be carried out about their rights, the staff should be trained for implementing the patient's rights in their day-to-day work. The staff needs to be trained on detecting the violation. So a lot of times this is something that is found wanting. So we need to train our people. Firstly, we need to understand ourselves that what is the right, in what manner this particular right is implemented. Let me give an example here. We know that the diagnosis of a particular patient is a confidential information, and so are the test results. So in our hospital, for example, we do not allow the patient's relatives or anyone for that matter to have a free access to the patient's file. However, if the patient himself wants it, or there is a person who's authorized by the patient, nominated by the patient, then this can be shown to him. Now, so we do this basically to ensure the privacy of the patient's information and also to preserve the record, because sometimes the record can be tampered with. Now, just imagine a scenario where the lab reports are being released. So what is the method of releasing the lab reports? And if I can give you a very specific example, how do you release a report of HIV testing? Now, on one hand, we guard the patient file with so much of involvement and don't allow anyone to touch. On the other, we will allow the patient's report to be collected by just about anybody. So this is essentially because we may not be aware that the information in the patient report is also as confidential or as private as the information in the patient file. And therefore, we need to have a system in place where we figure out how to release this information and to whom this should be released. Then the staff also needs to be trained on how to report the violation of patient rights. And of course, this will come from training. Once we know how to detect violations, then we need to have a system in place how to report. The commonest way of reporting, or the easiest way of reporting these instances of violation of patient rights, is using the incident reporting system of the hospital. Now, every hospital which has implemented any bit standards would have implemented incident reporting system where you are reporting system failures, medication errors, patient falls. You may be reporting facility-related issues like electrical short circuits and things like that. So, the same incident reporting system can also be used to initiate reports about the patient rights violations. So every time a patient rights violation is reported, this must necessarily involve retraining. Please remember, most instances of patient rights violation will be without the intent to really harm the patient or to violate the rights. So therefore, our first action has to be retraining of staff and ensuring that they understand and they implement the patient's rights in a manner in which it is desirable. So retraining and relearning is our first step of action. And the second step, if there are repeat violations and if people are not able to comply with the requirements, and then of course there can be a disciplinary or a punishment that can be included. So this is about all I have